the Estate Police Association represents those officers who carry a precept after a course of study and an examination administered by the police service through the Commissioner of Police. Security officers do not have that. They don't have that precept, right, and that authorization. The authorization that the precept carries, it gives you all powers, rights, immunities, and responsibilities of that of a police officer below the rank of corporal, right? A security officer has not yet attained that. The Private Security Industry Bill, in its present form, envisages forming an organization, an authority to regulate the private security industry. In doing so, the proposal before us, the proposal before the Parliament, is for the officers, the estate police officers, who are employed by private companies, meaning those who are not employed by the state enterprises, being that those are Airport Authority, Port Authority, T&Tech, WASA, and the likes, be put into this separate entity and we call the private security industry. Now, in the private security industry, you have companies such as Amalgamated, Allied, Innovative, G4S, all those companies, they have agreements with the association. They have estate constables employed there. Good? This bill now, if it's passed, will disenfranchise those officers, those estate police officers, because the proposal is for them to hand in their precepts and move away from the coverage of the Supplemental Police Act and go to a place where there's no representation. So, look at this scenario. You're working with a company for 20 years, 15 years. There's an agreement between the association and the company as to the terms and conditions. And the government is now saying, through this bill, that they're going to take you out from there, but not preserve your terms and conditions. Put you into an environment where there's no representative body. The association would have, and this public notice, public aware now, that the Minister of National Security, Fitzgerald Hines, indicated recently that they were bringing this bill to Parliament because there was a need for security, private security companies to support the crime effort, to supplement the efforts of the state apparatus, being that of the police and the army. Fine. We all in this fight together against crime. Question now. If you are to supplement the state, why is there a need to take you out from the control of the state? At present, an estate police officer is subject, or he falls under the Minister of National Security, the supervision of the Commissioner of Police, right? And the employer as it pertains. If you are going to put people to want to supplement the state, why would you want to remove the protection? Why would you just want them to be functionary as any citizen? Right? That citizen, meaning that any citizen has the right of arrest under common law. That special security officer as envisaged in the Act, and the security officer has no right, no power to arrest except under common law. So how do you really envisage this arrangement working between the private security without the right of arrest, the powers of arrest under the Supplemental Police Act, right, versus what it is your stated intention? We just cannot reconcile that. You're going to put people in harm's way. There's a number of issues concerning liability. They are going to be able to carry firearms under be issued a firearms employee certificate. There are a number of alarming things with that, where we have drawn it to the attention of the public, right? We have been having conversation with some interested parties, and we've been trying to get the authorities to say, listen, this issue of the firearms in the private security industry, and we saw what happened where there was a recent matter where one person had 27 firearms, right? That there were companies who were getting around that because they were just applying to the commissioner, and so you had people who were in fact security officers carrying firearms, right? Which was not the practice, right? Because in the state sector, we do not, you cannot, and no state company would give you a firearm users employee certificate unless you are precepted. Okay? But in the private security, that was happening. So, that is an alarm, because there are many instances where people will come to us and say they are a state constable because by virtue of them being able to carry a firearm. When we drill down, we recognize that they were not an estate constable, but they were carrying firearms. So that was a red flag, and the question now, why it isn't necessary, bearing in mind that the Commissioner of Police is still responsible for issuing of FUCs, right? The Commissioner of Police can set the examination, right, to deem you competent to be carry out the functions of a state police officer. In essence, the Supplemental Police Act always was a private security industry bill. Always was, because there was a component, there was a definition for employer. The employer could either be private or state. So our position is, one, that regulate who comes in, how they come in, how they operate. The other issue is to leave it within the Supplemental Police Act. In its current state, there are some designations concerning special security, special constable and rural police that is archaic and needs to get out. Yes, take it out. But replace that, because it was always a hybrid, state and private. State and private. Why disenfranchise thousands of people? Thousands and thousands of people from access to a representative body? Is it that people feel uncomfortable that the Estate Police Association will be able to represent such a large number of people because the minister himself quoted 50,000? Is that the consideration, or is it an attempt to get around representation issues? Is it an attack against labor again? No. Those are the questions that need to be answered. So, you want to take an estate constable, send them in the private security industry. In that private security industry now, they're going to be under the Minimum Wage Act, right? They're going to be workers, and they could be considered minimum wage act. And we would have shown, we would have written to the Prime Minister, we would have written to the Attorney General, we would have written to the Minister of Labour, and we would have been on our radio program on I-95, making the case that what has happened in the security industry, where the Minimum Wage Act is concerned. And I just want to bring it out clearly. If you look at the minimum wage sectorial order, the Minimum Wage Act and the sectorial orders contained therein, there's a marked difference between what obtains in the security industry and what obtains in the other sectorial orders. There are no provisions at this moment, none, absolutely no provisions in the Act for annual leave, sick leave, and even maternity leave. But already maternity is subject to a separate act. The association has in its possession a document signed by the then Minister of Labour, Ken Collis, in 1994, which gave all the provisions for annual leave, sick leave, provision of uniforms, and all of that in 1994. That was replaced, gutted, in 1995. So at present, security companies do not have to provide annual leave and sick leave for the officers. And some, even when they do, it is not in the prescribed amounts that other workers are entitled to. And you're saying you need to fix that. You need to fix that. If you're going to have this industry operate, right, you need to fix that. The laws that constricts the representation issues, right, that affects the people in the industry negatively, the parliament cannot discriminate so negatively against one class of workers. That it was allowed to happen from 1995 to present, right, is a travesty. But we are bringing it to the fore now. And this is something that must, because are you going to tell me that the normal workday as determined by the court, a judgment in the special tribunal, that the normal workday is 12 hours. So you have people working 12 hours in this industry and not subject to the minimum wage act, not subject to getting annual leave. The body breaks down, you're tired, being low paid, you're working extreme hours because your hours with what helps you with your auntie. The issue of back pay, overtime, nearly non-existent. People work stretches of 24 and 48 hours without overtime being applied, even places where there are agreements. But they are victimized whenever they're trying to bring forward, so they're very afraid. Now, how do you have an act of parliament and not fix the things that impact the people that you're moving across there to? Those are simple fixes. Fix those things first. Put it under the Supplemental Police Act and allow people the opportunity to be represented, to collectively bargain. We must protect collective bargaining at all costs. This we see as an attempt to get around the collective bargaining issues and to keep them in a perpetual state of slavery. Because this is what this is. Tell you when to come, when to go. I think I don't have to give you no leave, I don't have to give you no sick leave. So like as on the estate, whenever a slave is down, it's production time down. So the slave there, the master going, whatever means, because I have to get you up as quick as possible. The slave now don't want to get sick because he's afraid. The slave works sick because the slave has to see about his family. And that is what we face in here. So you have companies doing these things and the state is emboldening them by not acting on behalf of these people who work basically at minimum wage. And if those acts, the amendments that are made, as is envisaged, and the new bill is passed in its present form, with all those protections being addressed, then the parliament will be complicit, the entire parliament will be complicit in a continued abusive relationship between the state and the working class people in this country. The working class must stand up. The state has a responsibility. They cannot abdicate that. The parliament, members of the government, the opposition, the senators in the upper house, the independent senators, everybody has an obligation to get this thing right. How could you have amendments to the Supplemental Police Act and not consult with the Estate Police Association, who is named in the Act? We are the only association that is constituted by law. We are named in the Act. It says, for the benefit, for matters which a union is competent to bring, there shall be an Estate Police, the organization called the Estate Police Association of Trinidad and Tobago. But you are amending the legislation without giving us the benefit of foresight and to comment. Again, that speaks to a level of arrogance. It speaks to a level of disrespect for labor. And it cannot continue. And I want those members of parliament, both on opposition and in the government, those of you who have a conscience, to listen and say, listen, we have to regulate, but we need to speak with these people. We need to get their point of view. We need to, there are new things that are coming up. As things go along, things come up. And we have been trying to get to the powers that be. As I said, we wrote to the Prime Minister on this thing. All we got was, we got an acknowledgement letter. That is all we got to get, an acknowledgement of receipt. Right? So we don't know how far off, well, these amendments so that what we propose, we don't know where they are. What we do know is that you want to take people out, don't have them move from where they are safe and put them to where they are more exposed. Questions continue. Who is going to negotiate for those persons in the private security industry? If you're taking thousands of people out from estate police and putting them in this private security industry, who is going to negotiate? That bill that they're proposing, they have one of the persons on a board will be from the Ministry of Labor. How could that be? And a dispute will have to go to the Ministry of Labor. How would that work? How would that work? So it's there, and it will seem to somebody reading the bill, well, they're putting things in place, but how would that work? Is it an attempt again to have this authority deal with labor issues and get around the industrial court? Because they will be workers under the act. So is it another attempt again, because we know that there was an attack on the industrial court? Is it another attempt again to get around that? So you don't want to deal with the Estate Police Association. The Estate Police Association, as a matter of fact, we have a matter right now that is at the Privy Council, a representation issue, where the RBC versus the EPA. Curiously, comrade, the special tribunal indicated that, upheld the submission of the RBC at the time, that the association didn't have local standing, despite the fact that we have sole representation rights by law, because there was no branch board. That was appealed to the High Court. The High Court upheld the decision of the special tribunal. We sent it to the appeal court. The appeal court gave a judgment and said they agree with the association. You cannot tell the association that they could bring any matter that a union is competent to bring. You have sole representation rights. There's something called the branch board and there's something called the central committee. Okay? Central committee is us. We represent the central committee. Now, look at the dynamics of this. The persons who appeal is the special tribunal, not the employer. So the place where we go for justice is appealing an issue of representation to the Privy Council. Those are the things that need to be addressed. Those are the things that have been happening. Those are the things that the public needs to know. The place that we go, I want to repeat it again, the place that we go for justice to make sure people are represented is the special tribunal. And the special tribunal is saying that because you don't have a branch board, you cannot be represented by the association by virtue of that, even though the law says quite clearly the Estate Police Association have sole representation rights. The money that is being spent to appeal that to the Privy Council is paid by the state. Comrades, people, the security industry has been abused far too long. There comes a time when we must take a stand. And you, the public, because everyone knows somebody who is in the security industry, have something that's littered with women, especially now, right? You have your aunt, uncle, nene, nephew, niece, somebody in this industry. You know somebody you went to school with, right? These are the excesses that are taking place. I could give you documentary evidence of the companies, SWAT, like you call it, because they wrote me and tell me that they can victimize, they can coerce anybody from joining the association because we're not workers under the act. Right? These are the things that need to be addressed. Why, what happened in between 1994 when the security industry was given all the provisions for annual leave and sick leave, provision of uniforms. Now people have to pay for uniforms in the private security industry. What happened between 1994 and 1995 where they took out all those provisions? Who was in office? Who was in office in 1994 and 1995? And who is in office now? The inquiring minds want to know. So we need to fix this. And if this is the opportunity, the government has said that they don't need the support of the opposition, but that places that even more responsibility on you now to get it right. Because if you don't need the opposition support, then you have to get it right now. Because what you have is power, absolute power. And in doing that, you must listen to what we are saying. We have brought to you the excesses and the recommendations. It is a simple fix. Look at the Supplemental Police Act. Have this authority to regulate the who enters, how they apply, what are the requirements of them, but the real issues, the operational issues as to how the people in the industry, right, are treated, has to be through collective bargaining and representation issues. And that is what they're trying to get away from. And we cannot sit back and say nothing. So tomorrow, the 6th, I want to ask all estate police, all security officers, to meet us outside the parliament. Let us show the government, let us show all parliamentarians that we are seriously concerned about what is going to happen inside of the parliament. Those of you who are sitting in proprietary security and in-house security in the state companies, don't feel comforted. Do not feel comforted at all. Under the Supplemental Police Act, they said that the amendments there too, that estate constables will reside in state companies and statutory bodies. TSCT is a state company. What did TSCT do? TSCT said to us, they don't need estate constables anymore. And they retrenched 27 persons, right? They also engage amalgamated security who have estate constables. Good? That is the playbook, right? So while they say, in a sense, that the estate constables will reside in state companies, look at what the state companies doing. Look at what happened at Petrotrin. They had amalgamated takeover immediately. Look at what happened at TCL. TCL said to the Commissioner of Police that we're going to close down the department and we're to revoke the precepts. And after that was happened, then they informed the officers that you're no longer estate constables and are retrenching you. Those matters are before the courts, right? So there is an attempt to bring down the salaries because, again, the salaries are better. Good? Estate constables get a premium over security officers. So there's an attempt to bring down this. In TSTT, you want to bring it out again, and I want this to be clear. TSTT accepted a bid of $24 per hour from Amalgamated Security Services to provide security services as state police officers for the operations at TSCT. Right? Amalgamated pays $20 per hour for an estate constable. Right? They pay $25 per hour for an estate constable who carries a firearm. So that is $25 you're paying for an estate constable who carries a firearm in TSCT. But your bid is $24. Now, in other jurisdictions, that is a crime. The procurement legislation has to be talking about that. You cannot accept, the company has an obligation to ensure that the provider, the service provider, is able and is not engaging in any sort of unfair practices. The question has to be asked again, is it that they knew what was happening, what was going to happen? Why would TSCT engage in that kind of behavior? Why? They are state company, it's taxpayers' money. But how could I decide to take $1 loss? Because there's a long-term plan and it could be extended to other companies. And the other companies now, the other security companies, will be hard-pressed to win any bid, any state company now. You can't, they have deep pockets. Those companies and them, they can't compete. So what they do, they bring it down, take the licks here now to have total control, to monopolize the entire industry. Those are the things that have to be addressed now. Those are the things that have to be addressed before you got into the nitty-gritty of the thing. And if you don't address those things, you will just be complicit in these kind of operations, these kind of shenanigans that happens, that people could underbid to the extent to kill everybody else and end up with a monopoly, right?